I know Rick passed out, I don't think there was enough of these, but we had about 100 plus of these sheets, which basically gives you the website for the Bureau, where there will be information where you can sign up to be on the listserv. And for those of you that don't have it, let me give you that website. It's www.michigan.gov/medical marijuana. You can go there. We will post things as quickly as possible when we have information. It also allows you to sign up so that if there's eventually some interest in being part of the stakeholder groups for any of the topics that we're going to be covering, we want people to be able to participate through that listserv. It's like a listserv. You know, you'll get a notice. Every state does it. We think it's important for us to do it as well. So let me get started a little bit. Let me dispel some of the myths here. We've heard a lot of myths and rumors and innuendos and everything regarding this industry and what's come up to us through the department. First of all, there are no licenses being issued right now, period. So if you hear that from somebody, that's absolutely a lie. Secondly, we don't know who has a direct path to the department because we don't even have licenses yet. And finally, applications. Nobody has an application. We are yet still building the application, utilizing the statute and all the other things that need to be interpreted to give us the right information. So if somebody says, oh, I've got the application the department's using, they're wrong. So just a couple of things there. Other thing that always comes up is, why are you guys using H versus J, or, not cannabis? Well, first of all, H is found in the Public Health Code from the 70s. And through all the statutes, nobody's ever bothered to change it to a J. So, we're stuck with what we have. So we accept both, and just so you know. I got asked on late Friday about, from the Detroit Free Press, all you guys probably saw the article, what have we been doing? We haven't been sitting on our hands, I'll tell you that. We have been meeting with people, anybody that wanted a meeting with us to come in to talk, discuss, raise issues, and there are still a lot of issues to be decided. We've been talking to other states, obviously Colorado's a lead, Oregon, Washington, any of those people that have been in the business for quite some time, we've been talking to them. We don't want to reinvent the wheel. Everybody's got some good practices. We're trying to adopt those as quickly as possible. We've been reviewing their statutes, their rules, their timelines, everything that we possibly can so that we can get this program up and running. Because we have a deadline, December 15th. Everybody's aware of that, correct? December 15th, we will be accepting online applications. Now, we expect a lot of people, honestly, to go there, grab the application, pull it off, print it, and probably walk it into the office in Lansing, let's be honest. We'd love to do a lot of online, but I think the reality is a lot of people are going to fill it out and bring it to Lansing. And that's where we'll receive them, in Lansing. So there's not going to be a Detroit office or a UP office. It will be in Lansing for right now. We're working on IT. As you know, under the bills, there was a specific statewide monitoring system. We had to go out to RFP to do that. I spent 2 days in a vendor spotlight with IT folks. Now, I like IT as much as anybody else, but 2 days of vendor spotlight was enough to put me over the edge. We have picked, and I'll get a little bit more into the detail there, but we did the RFP, we put it out, and we selected Framewell Metrics. Some of you, if you're familiar with Colorado or Maryland or some of the other states, that use them for the seed to sale tracking program, that's who we have chosen. And then we have the licensing side, which is a whole nother IT program. We are currently using the Excella platform. Now, I'm not sure if I got any licensees in here, because LARA is 20 plus bureaus and agencies. I cover everything from liquor to energy to construction codes to fire to marijuana, to employee relations to workers' comp. Professional licenses, builder, contractors, skilled trade guys, electrical, mechanical. Anybody in here, any of those licensees? If you've been on there, you'll know what the Excella platform is like. That's what we're using for the licensee side of this. And there'll be an interface so the two of them can get together. I think it's important, and I think Justin's probably touched on it, and any other prior speakers have touched on it. you can educate yourself in a lot of this, you know, by reading the statutes. I mean, the statutes will definitely give everybody a framework of what we're looking at. There are a lot of, I'll say, holes, things that need to be subject to interpretation, and we're working through those in terms of trying to figure out what is the best process to go through, and what's the best practice. I mean, I can, you know, list a couple of things off the top of my head. Idea of co-location. Can you be a grower and a processor in the same building? Not clear in statute, but we can do it in rule. Secure transporter. Do you have to have a license in every municipality that you're in? Or do you just have one that's a bricks and mortar and you can go wherever you want to go, depending on what your business plan is? Those are a lot of the types of questions we've been asked, and so we are trying to work very closely with the Attorney General, our own selves. I mean, I'm an attorney, Colleen's an attorney, get input from industry, what's the right direction for us to go. So with that, you know, we did ask, even from the first get-go, we asked for some legislative changes. I mean, just going through this, you know, from a regulatory thing. And understand, LARA is regulatory, and I think that's maybe one reason why the legislature didn't put this in MSP or, you know, in Treasury or liquor control even. We are the regulatory body. I mean, we regulate and license over, you know, 1.5 million people. So we know what licensing is all about. We know the regulatory side. We are not the criminal side here. That will come later through other people, but that's not us. We're the regulatory. Which, you know, some people don't like as well, because, you know, as a regulator, you're damned if you do and damned if you don't. If you didn't do enough, you know, you're a bad person. If you did too much, then we're over-regulating you. So we have to walk that fine line, and hopefully, you know, with your guys' support and, you know, guidance and information and comments and educating us even further, you can give us that goal to meet. We asked for a few things in the legislation. Probably all of you are aware, maybe Justin touched on it, background checks. The legislature in their wisdom put up, you know, everybody's subject to a background check. Well, unfortunately, the FBI doesn't take that language. We had to have very special language that triggered the FBI review. Otherwise, we would have been just collecting fingerprints, sticking them in a drawer, and not ever looking at them. So that was the one reason why Senate Bill 433, sponsored by Senator Jones, passed so quickly to get done, because we have a lag time. The FBI takes like 3 months to code it, put it into their system. State police take about 3 months. So we needed that done sooner rather than later. We are working with the legislature on some other clarifications. One that is very important is the municipal side. If you read that section 205, it's pretty convoluted, to be honest, from a regulatory perspective. We need, you know, clear guidance as, you know, local sign off, here's the facility types we approve, we go forward. I don't need to get a copy of their ordinance, I don't need to get a copy of their zoning ordinance, because we are not wading into that. We just need to know that the type of licensee is approved, not the individual, but that, you know, the 3 types of grows, they're allowing them, that's it. That's all we need to know. And we'll have to communicate that back and forth with the locals. So, you know, we have to set up that database and that communication class, but that's really what we want to know. You know, if locals want to send in, they got bad actors in their communities, they want to put that in, to me, that's a renewal issue. That's not a precursor issue. So we have a lot of those kind of things that we have to work at. And it's a lot, and we're trying to do the best we can. So let's do rules. Everybody understands rules to some degree. That's how we're going to operate. We have 2 types. We have emergency rules, and we have the regular rule process. I'm going to be honest with you, this is July. We have to have a program up and running in December. We are going to be doing emergency rules. Emergency rules don't require stakeholder input. It's not that we're not listening, it's not that we haven't seen a lot of comments come through the website. Colleen's gotten thousands of emails from individuals asking particular questions. A lot of people have raised issues that we need to have addressed. Co-location, perfect issue. Not addressed in statute, but we have the ability to do something via rule. It is our goal, my goal, because I want this program up and running in December. It is my goal to make sure that we try to get those emergency rules out by early fall. That way, at least everyone will have an opportunity to see what the rules are, what the standards are they have to play by. It is going to be a skinny rule set. I'll just tell you that very honestly. because we can't capture everything that needs to happen in a regular rule set. We can't. We can't do that and get operational by December. But we are going to give people enough of a framework that they know to make business decisions. And I think that's what everybody wants to know. What's the playing field? What does it look like? On renewal, when we have an opportunity to go through a regular rule cycle where we have stakeholder groups, hopefully the advisory panel will be appointed by then, recommendations, a longer lengthy process for public input, that's when we will have time and the rules might look a little different than what you began with. So kind of keep that in mind as you're building business plans. You know, here's kind of what it looks like when you apply, but it could change. And I think every state does this. Every rule set changes almost rapidly. I mean, the games change every day or every week or every month. At least all the notices I get from Colorado tells me that the games change all the time. So that's how we're going to operate. There are still a lot of questions we have to flush out, but it is our goal to get those by early fall so people can start making decisions. Our other goal is to set up and make sure that people have a checklist for the applications. Might not have their actual application in hand because for us, we don't want people turning their application in early and then us having to return it and then getting into the battle of, oh, well, I turned my application in, you should have it. We're not going to go there. And so, you know, we're going to give people a checklist. It'll be the application. These will be the documents that will be required, and you need to go forward. And we hope to have that almost simultaneously when we do the emergency rules. Hopefully, well before the, December 15th deadline for us. The other thing, we're going to do training sessions. I mean, so I'm trying to back these kind of up from December to like late October to early November. We want to get out in the field and basically have training sessions, not only with the metric folks, but for people on Excella, for the licensees, so they can actually look and see and ask questions as they begin to work through the two systems. And that, I think, is an important thing. It's an important tool. We'll go statewide. We're already anticipating it. We'll probably work with MSU, who has a big extension program, to kind of locate some of these training sessions, but we want people to know that they can go through. Speaking to the IT, the Franwell metric, everybody is entitled to go whatever third-party vendor they want to go to tie into the state system. You don't have to use Franwell. In fact, I don't think they do retail. I think they all do just government. But if you're using any of the other big vendors, NMJ, Freeway, BioTrack, some of the other guys, we're going to have an API, and you're going to be able to log into that. And there probably will be some restrictions on the API. So your person, and we're going to put these up on the website. We think it's important. If everybody's certified through the APIs, it'll be a laundry list. So, you don't like your vendor after a while, you can change to another one. But we want to put that information up. But there will be some limitations on the APIs because we want to make sure we get accurate data. And that's important when it's coming into the state system. We've been told that there's been some states where they've had real issues with the data being, imported into the state system. So we definitely want to make sure that those things are right. But we want to also give you the information so you guys can, pick and choose at your leisure who you want to use as your third-party vendor if you're doing the point of sale at the provisioning centers. Let's see. Let's talk about the board. Okay, board recently appointed about a month ago. Held our first meeting. Overwhelmingly, pushed to the max in terms of room space. And I will be the first one to apologize. We thought maybe 200 was going to be, sufficient space. If you know Lansing at all, you know that there's very limited space unless we're paying for a big, large room at the Lansing Center. Now that's a big cost. I mean, Williams, we get to use for free. So some of the things that we're looking at in terms of that board, in terms of the next meetings, and we know we have one set for October. But we will have more. The board needs to be educated. They need to hear your comments. They need to hear your concerns. They need to hear your questions as to what needs to be answered via rule. So anytime you can, convey that kind of stuff to the board, that's the kind of information they like. They don't have answers. I will be very honest. They don't have the answers. So we want to make sure that, they can hear and understand what the industry needs are. And that's part of just doing the responses in a public comment kind of format versus I need to know if I'm going to be able to get a license in this particular jurisdiction on this particular day. With that kind of stuff. They can't answer that. So, I mean, if you have genuine concerns comments that you think this is the way the industry should go, secure transporters aren't needed if you do co-location, something like that. Those are the kind of voices and things they need to hear. So with that, we'll talk about the board, but the other thing we're gonna try to do is we're gonna try to get the streaming in, and we will publicize that well in advance of any meeting. So therefore, everybody doesn't have to show up in person, obviously, unless they wanna comment or, send a question. Everybody's got the website now. If you got questions, send them in, we'll look at them. I can't say we're gonna immediately answer them, but, I have a staff of about 7 people working on this total project. That includes IT. So we are working to the max. We're here on a Sunday with all you folks, so this is pretty much our job right now. Let's see, what else? IT, I think we've covered it. We've covered Franual metric. Go on, to the website and obviously advance there. Other than that, I will tell you guys right now, I can probably go through 4 or 5 questions that's probably on everybody's mind. If you want me to. One is probably the dispensary issue. What happens? You know what? We're trying to finalize the discussion about that, I will be honest, because, seriously, there's a lot of locals that have authorized, dispensaries within their municipal bounds right now. Viewpoints that they are operating illegally. Come December, you have no state licensure, you're operating illegally. So, law enforcement, do they enforce it? I don't know. Yes, no? Do we take it as a consideration of your application when you apply to us that you've been operating illegally, after December 15th? That's a gamble. But that is one question we want to get out there sooner rather than later in terms of how we do it. Because I think a lot of dispensaries have, let's be honest, a lot of product out there that, where does that go if all operations cease immediately? It is a difficult issue because we have a lot of locals that have authorized this and they've been operating without enforcement within the municipal bounds. And so we have to address that via a rule, but we also want to do, in my mind, what we're available to do for business owners to be able to say, hey, we can't take all this product anymore, we just need to kind of, dwindle our supplies, and then eventually go, when we get licensure, we can re-engage. Or it's just subject to enforcement. And then, what's the applicability to your application when you actually apply to the state? Big question. Another big question is the co-location. Everybody thinks it's all right to have a processor and a grower in the same location, even to the point of having a provisioning center in the front. Locals have jurisdiction over growers. It's agricultural or industrial. You could do a processor and you could do a grow in the same building. According to those zoning requirements, I would say. Whether they can have a provisioning center on the front, retail office of an empty manufacturing building, that's gonna be up to them. That's not gonna be up to us. What will be up to us is whether we allow that, whether you have to have separate buildings. The other issue, big issue on the plate that we haven't decided yet is, can you have multiple licenses? Can somebody have, 3 Class C level licenses, grow 4,500 plants? Can somebody have, 2 Class B licenses? Well, you're already into the C, so it's really only gonna impact the C licenses and how many you can have. We look at it from a couple of different angles. Why the statute says, 1 license. One, we can't limit licenses. So if you think about it from a practical standpoint, you could have somebody come in and partner and get 1 license and then partner with 4 or 5 other people and have the ability to get more licenses. So from a regulatory perspective, that would be background check, background check, background check, background check, background check, for the same individual basically getting multiple licenses. We are working through that. The other big question, agriculture. We've had a lot of discussion with builders, building inspectors, I should say, regarding agriculture. And between us and the Attorney General, we've had a little difference of opinion, so we're trying to work through what that role is and how does right to farm apply to people building a building in agriculture. Greenhouses might become very popular. Currently under the Act, they're exempt from pulling a permit, but they're not exempt from the building code itself. You still gotta have electrical, mechanical, and plumbing, especially if you're gonna have employees and you're gonna be required to have a bathroom. So those are the kind of issues that we are trying to get as much information gathered so we can make an informed decision And I'm gonna be honest, we're not gonna make everybody happy. That's just gonna be the nature of this industry. We are gonna try to do the best that we can, but we're not gonna make everybody happy. But, you know, we got a long way to go on this. So it's just the start, and, you know, a lot of other states have had multiple years in doing this, and we're just at the beginning. So we continue to work through all of this with you guys. So I think, Rick, I had time for a few questions, or hopefully not. And I will answer them to the best of my ability, to be honest. But there may be some that I just say, we gotta deter, you know, TBD, you know.
Well,
so.
excuse me, as a program coordinator, I think I want to get the first question in. Is that okay with everybody? All right.
Oh, hey, you know what? Let me talk one more thing. I forgot. Because Rick, I think you raised this at the board, the advisory panel. If you read the statute, half of the advisory panel requires a licensee from the industry. Well, licensees don't occur until after December. So, you know, in terms of the advisory panel, even though it was supposed to be appointed 3 months ago, or 3 months after the effective date, I should say, half of it couldn't be appointed. So I think the governor is looking at individuals from the sides that is allowed, which is basically law enforcement, the agencies, and locals. We have asked the legislature to do a quick fix on that so that we can get the stakeholder group and the advisory panel going much quicker. But, you know, it is summer, they're not in, you know, we don't know if it'll get done in the fall. But tying back to that is, I think what we're going to do and what we're going to pursue is the topic of rules. We're going to be putting out information, so I appreciate if all of you sign up and want to participate in any rule-making activity for input. Something similar to Colorado does is you put your name, your contact information, and like a 150-word statement as to why you want to be on the rules committee for this particular thing. We're probably going to move forward with a stakeholder group versus appointed advisory board members, because we got to get the rules going. We're going to be running parallel. Emergency rules are good for 6 months with the potential for an extension for another 6 months. But the regular rule-making process is a 12 to 18-month process if it all goes well. It's a lot more lengthier because of public requirements and public notice, public hearings, you know, come back and forth and with the rules. So we will be starting those work groups, and so I encourage you all to get on the website, because that's where we're going to get some other industry input without necessarily being a licensee per the act. So I just wanted to mention that.
Well, thank you very much for clearing that up. I did have just one question, and that's in regards to the Open Meetings Act. When we're forming administrative rules, that should be taking place under the guise of the Open Meetings Act, where there's dialogue, there's reporting, there's research available and subject to FOIA. Is that the plan? Even if you work with a stakeholders group, will you still operate in a way that's transparent in government?
Yeah, I mean, I think it's important, you know, in the open meetings and the rules process, you know, emergency rules is different. In the sense of the stakeholder input is not necessarily needed there. It's basically the department can issue the rules under emergency rules. Correct me if I'm wrong, Holly, but it's a lot limited, yeah, in terms of emergency rules. And so that's why it's important to hear from you. That's why we've been trying to do our due diligence and educating ourselves, and, you know, going to other conferences, going to this conference, going to other areas to listen to everybody as to what the concerns are, as well as meeting with just about everybody we can. But the regular rulemaking process is definitely open meetings. So whether you're chosen to be on a stakeholder group, you'd still be able to, you know, probably come to a room, depending on the size of the room again, and be able to have some input. But that's why we want to open this dialogue up about what we're doing. And somebody had raised Facebook and Twitter and things like that. You know, licensing, LARA has a Twitter account. We are looking at the Facebook, you know, for posting information and stuff like that for individuals. But, you know, certainly our website, we're hoping to it be a lot more robust in the next coming months as to what we're doing and what we can start to anticipate. So we will try to get it out there, but that's where it's at. But transparency, we're going to do the best we can in terms of the rulemaking. But we've got to get it out there. We've got to start.
You have time for maybe one question, and then we'll switch up.
Yeah. Go ahead.
You know, it's been 8 years, and somebody here from Arizona has an Arizona medical marijuana card. I mean, how come the picture is not on the card after 8 years?
Oh, in terms of the medical marijuana registry program?
Right.
I don't think it's authorized, correct? Yeah. I have to check, because that's the other act. It's not the licensing act, but it's the other act, which I haven't looked at in a while. But, you know, the cards are there, but there is the ability, I think, to have a picture, which would probably be helpful, especially at a point of sale, for us to encourage it. But I will also tell you that the medical marijuana registry program software is based on L2K. Okay, L2K is 2,000. So you think about, you know, 250,000 patients. We're doing licensing with an old system, but go ahead.
Well, yeah, that's an old excuse, you know.
We should be able to capture it.
I mean,
just
what's
wanna
wrong with
verify,
Secretary
though.
of State
yeah.
to send a picture over? You know,
Yeah.
I work in
I
IT
do
too.
want to verify with that. I do want to verify that that's required, or we are allowed to do that, because we should, to be honest. And I think it will be helpful with point of sale, because if somebody's presenting a card, at least they can identify whether that actual person is there. So I appreciate that. Yeah, I appreciate that.
All right, thank you.
Is LARA looking for bank accounts, proof of funds, any type of escrow? Have you talked about the money that will need to be proven that you have?
We have talked about the financial, what do they call it, financial probity, the financial resources of the individuals, and recognizing that not everybody's gonna be the same. Everybody, you know, might have bank accounts, some may not have bank accounts or financial documents. So, I mean, we're gonna try to be broad-based in order to capture a lot of people who are trying to apply for licenses that may not have some of that documentation. And hopefully we can provide a sufficient number of types of documents. But, you know, certainly if anyone is operating in other states, I know there's some folks here from Arizona and maybe some other places, you know, what's the kind, we've been looking at their applications and certain documents, and a lot of it is just based on, hey, can you go out and get a surety bond? And, you know, that's kind of, you know, kind of the effort of where a lot of states have gone. But there might be the opportunity to actually have some financial documents in terms of, you know, income tax returns, or you run through a management company, or you have multiple other entities that we could look at. We just have not decided, but it has to be done soon, because we have to build that into the application of what the required documents are gonna be.
I understand the protocol, but have you mentioned a number yet, 50,000?
No, we have not, nope. And you know, and I apologize, because I mean, I know you guys are all eager for answers and trying to figure out from a business perspective what you're gonna have to have. So, like I said, as soon as we can get more information out there, you know, the better off I think we're all gonna be. But there are a lot of questions. You know, financial is just one of them. I mean, we've asked the legislature to put in kind of a hold harmless clause for the banks and the CPAs. I mean, the CPA, the Board of CPAs passed a resolution basically doing what the national level had done regarding if, you know, CPAs want to advise clients that it's not necessarily an ethics violation. We've kind of done the same thing for banks, but we all know banking's a big issue. Nobody's tackled that yet. I think, you know, Treasury potentially could look at a closed loop system. They've now been authorized in boilerplate statute. So, I mean, maybe that's the direction they want to go in terms of the collection for the taxes. But, you know, we got a lot of moving pieces here that we are trying to do the best to accommodate. And I feel bad that I can't keep giving you that same answer. So, go ahead, sir. Back. Yep.
You mentioned that no license was necessarily needed right now to build, however, a permit be required.
Well, no. You got that kind of reverse. So the ag buildings don't require a permit when you build in agricultural areas. They call them permits. However, it's still subject to the building code. So if you're running electrical through there, mechanical, there. The other key point of this is if we as the licensing body say, you also have to have this security, this there, before we'll give you a license, you know, while you might not got a permit with the local, you're gonna have to have some other oversight inspections from the locals. So it's not like you're gonna be able to just kind of get out from any inspections at the local level for any of those type of agricultural buildings. That's kind of the direction that we're going to. But there's real confusion for the local building official, because they've been led down this, you know, if it's an ag building, we don't permit it, we don't go in, we don't do anything. Well, you know, these industries are gonna have to have electrical, mechanical, and if you got employees, you're gonna have to have obviously plumbing for restrooms. You know, you're gonna have egress, you know, everything else, fire, whatever might be the case. From a licensing building perspective, so somebody's gonna be going in there and doing inspections on those buildings, even if they didn't pull the original permit under that. So it's a difficult issue to understand, but we're trying to work through that to get clarification.
Director, one more question.
Sure. One more question.
Do you have any plans of streamlining the process of approving for a qualifying condition, approving those? Because we have the medical marijuana review panel that votes to approve that, but we've had some that have been overturned by the director. Do you have any? And I'm a parent of a son with autism,
Right.
so we had tried to get that twice, and it was overturned last time by Zimmerman. I'm thinking of the big picture here.
Right.
And streamlining that process, not only for autism, but other qualifying conditions
Right.
that have been approved in other states.
Right. And I think the process is set up in statute. I'd have to go back and look at it for sure, because I haven't had any, honestly, I haven't had any petitions come before me. And actually, did have an autism group of parents, I don't want to say autism group of parents, but parents with autistic children, reach out and said, hey, we want to do that. And I said, well, if I'm going to weigh in on your petition, I don't think it's appropriate that I meet with you. But certainly, you know, obviously with the changes in the current act, about the infused products and things like that, you know, there is an opportunity, I think, for the parents again petition for that. And that obviously is left up to everybody's discretion whether they want to do that. But I think the process itself is set forth in statute, so we have to go back in and change that to streamline it, which probably makes sense considering now we're going to, you know, medical marijuana, the licensing act, but that's a 3/4 vote to amend that and fix that process. So. All right. Thanks.
How about a big round